CBD is derived from hemp, which is now federally legal and removed from the controlled substance list, then you'll be able to get the trademark that you in the past could not get. So that's huge. And you also have to be able to make certain, there's like a new statement that the Farm Bill has kind of created for people to protect their CBD or cannabis or even THC products under trademark law, under federal trademark law. So it's an interesting statement. Again, most people may not be able to make, meaning most companies may not be able to make this statement, but if they can make this statement to the trademark office about their supply chain, then they will be able to potentially get a federal trademark and, kind of have protection over their brand or their logo. And the statement is that the goods that they're selling contain or are derived from cannabis, right? From cannabis with a delta THC concentration of not more than 0.3% on a dry weight basis. If they can make that statement in terms of their supply chain, kind of how they're creating their product, then they'd be able to give it. Then they'd be able to potentially get a federal trademark. That's huge. I mean, we've come a long way in the United States. So again, I've had clients where I've said, "Could you make this statement?" And they're like, "I don't think we can." Okay, then maybe we don't try for a trademark now, or maybe we try for the trademark and kind of wait until more regulatory decisions and guidance from the FDA, from the government, the Department of Agriculture kind of, trickle down. So, yeah.
Very interesting. And I wonder also, are they as rigid about the intent to use? Like, let's say someone does have a THC product, they want to trademark the name, they want to protect themselves for the future and file like an intent to use trademark application. Are they rejecting those as frequently as they reject the ones that are already in use because they're not interstate yet?
Good question. They're being kind of proactive about this, right? They know eventually that once they allow your intent to use application, which triggers like a 3-year period for you to start selling in interstate commerce in the United States, that you're eventually going to sell. And so why not, as a trademark office, why not protect the consumer by requiring the applicant now to confirm what, kind of how the product is made or where you get your CBD from or what the THC concentration might be. So yeah, they are being pretty rigid about that. I definitely think you cannot file a trademark application for anything in this industry without being rejected. I mean, you're going to be rejected, and it's okay. You can be rejected. You just have to then prove your supply chain. So yes, it happens to the people that are already using their marks in commerce, and it happens to the people that are intent to use, who have that intent to use their products or goods or services in the market, who have the intent to sell their products, goods, and services. Yeah, it's happening. It's definitely happening. I don't think a company should be scared of that. I mean, maybe they should be scared if they can't meet the requirements to get a trademark or make those statements, because they may not be able to get some sort of federal protection on the trademark side. Maybe they just go for the patent. But I think it's just the learning curve that the United States Trademark Office is trying to impose on companies, so that once this company goes global, right? If you think about like patents and trademarks, this is about global intellectual property harmonization. So the United States wants to make sure that they've crossed all their T's and dotted their I's and force companies that are in this field to cross their T's and dot their I's, so that when they take the United States trademark that they got here and actually go global, launch into Europe or launch into India or launch into Hong Kong or launch into Colombia, that they know that their seal of approval has that they put the company through the paces, and that trademark will stand up in another country where the laws might be similar or slightly different or more rigid. So it's kind of, from their perspective, they're just kind of looking out for the companies that are in this field. And so I kind of respect it. I've learned to respect it. In the beginning, it was like annoying, like, oh my God, just, get with the program already. United States Patent Office, Trademark Office, just get with the program. This is happening, this is changing, people are doing it. And so this is their way of kind of getting with the program.
Yeah, absolutely. And then if someone is about to go global, how important is it for them to file for patents or trademarks in the countries in which they plan to go?
Yeah, really, really good question. Part of the intellectual property process is understanding that the entire world is what we call a territorial system. Meaning, if you have a patent in the United States or you have a trademark in the United States, that's your territory. You don't have protection anywhere else in the world unless you take the affirmative step within the prescribed time to take that trademark and file in another country, to take that patent and file in another country. Make no mistake, if you do not have the patent or the trademark in China or Europe or South Africa or any country, then you do not have the ability to stop someone else from doing what you're doing, making what you're making, selling what you're selling, branding the way you brand. That is intellectual property. Having a patent or trademark is the entry that it basically gives you the entry into a country's, into a territory's court system where you could potentially stop someone, right? All the stopping of someone, infringing you or copying you all happens in an actual court of law in every country in the world. So it's the only way to do it. And there's a very limited time to do it. I definitely have clients that have, have like a patent in the United States, let's say, or filed a patent in the United States, and you only have 1 year from your filing date in the United States to start the international process. I would say the majority of companies in this space are giving up their rights to protect their inventions and brands in other countries because they usually don't adhere to the deadline that they have to start their foreign filings for a variety of reasons, and probably good reasons. Money, investment, I don't know where I'm going to be, I don't know where I'm going to sell, I don't know what the regulatory issues are in that country. Okay, fine. But just know that if we don't file by X date, which is 1 year from your filing on a patent or 6 months from your filing on a trademark, then we may not. This is not. We're going to lose that country. We're not going to have protection in that country. You can still market there. You can still commercialize there. You can still sell there. But if somebody in that country creates something similar to yours, then we're back to that original scenario that we just talked about, which is you won't have any standing to go into a court and prove that somebody poached it from you or infringed it from you or came after you, because the country there, the courts there will not recognize your rights because you don't have the corresponding patent in that country or the trademark in that country. So it all kind of connects for sure.
See, that's very interesting because you hear a lot about China, for example, poaching intellectual property from the United States, and it's usually a big complaint in the movie industry and entertainment in general, and also in manufacturing of like fine apparel and stuff
Sure.
like that. But what you're saying, unless these movie companies or apparel companies have filed for a patent in China, then it really doesn't matter.
Correct. There's the only way to stop anybody, to stop an infringer, whether it was intentional or not, from taking what you've made, creating what you've made, selling what you made, is to have the registered intellectual property in that corresponding country. Listen, I just to be perfectly blunt, infringement is going to happen, right? It's going to happen. I mean, it's almost sometimes something you want to happen because it's almost like a sign of that maybe you're doing something that's reached, the Far East or something like that.
Well, it's the
right?
best form of flattery.
Exactly. So it's a good problem to have. It's a terrible problem to have, but it's a good problem to have in some respects. But yeah, there's definitely infringement is going to happen, and just because you actually take a lawyer's advice and actually file the patents in all the countries that you think you're going to be infringed doesn't mean it's just going to stop, right? You literally have to affirmatively go after those people, right? I mean, the patent and trademark are supposed to be a deterrent factor to infringers in that country, but people are nefarious and evil, and it's going to happen, and people are going to do it. You just have to have the tools to fight them, and if you don't have those tools, it will be a really, really hard fight. Second, I want to with the world of cannabis, I've been doing this for about 20 years. So I've seen some emerging technologies, Bitcoin, cryptocurrency, 3D printing. Cannabis falls right in there, right? These are regulatory and ethical issues that are forming all around the world. Intellectual property is trying to catch up with innovation. It's a standard thing that we've seen in history. And with all emerging technologies, there will be infringement. It's going to happen because there is so much kind of unknown for the companies that are getting involved in this, like what I should do or what I shouldn't do, where I should go, where I shouldn't go, where should I protect, what do I do? So it's going to happen. But I think as an industry, as the cannabis industry kind of emerges and kind of comes out of its shell, and we're in the middle of that now, it's happening right now, it's so important that these types of scenarios of infringement, of enforcement in other countries, of people coming into the United States with, like, because we were just talking about the United States going to another country, but there are innovators that are doing things like in Israel or China or Hong Kong and trying to come into this country. And so it's so important that we as an industry embrace this and kind of be proactive about this, not reactionary about this, because being reactionary about these types of situations, it's probably too late at that point, right? We have to be proactive about that. And I get it. It means, oh my God, spending more money and I have to protect myself. But like, what this is how we grow as an industry. This is why you have service providers that are in it with you, right? We're in it with you, not just lawyers and accountants, everybody. We're all in it with you. We're all kind of putting ourselves out there to change things, right? And so it's not just going to be about the bottom dollar. It's going to be about like how we push things forward. I'm pretty passionate about this this subject matter, regardless of what kind of industry we're talking about, because I've seen how it trickles down in a bad way where people just kind of lose their rights and can't take back something that they thought they should have done because they didn't have the money to do it, or they lacked the education to do it. It's a shame. And so,
It is a
yeah,
shame.
it's
It
a
really
shame.
is. So this industry really did get its start, though, with a lot of grassroots advocacy. But
Yes.
in the very beginnings of this, and now even still, it's a mom and pop operation
Yeah.
in a lot of respects because it is so new and everybody's there's a big learning curve for everyone. But there are a lot of people who start out because they're passionate about it. They've got small companies. They don't have a lot of resources. They don't have the big, corporate dollars coming in with the big Wall Street investors investing in their company because they're just not knowledgeable about that aspect of business because they've just been doing this thing that they love out of a passion for something that they think will change the world.
Right.
So a lot of these people do not have the resources to go and hire a legal team to work on patents. They've got brilliant ideas and they've got brilliant products that they're putting out there. But I mean, if they can't, they don't have the means to really support protecting themselves this way. How else can they protect themselves? And are there legal advocacy groups that will usher them through this or help them finance it? Or how do people proceed? Because it's a really important thing that they need to do.
Yeah, there's a few strategies I think companies can adopt, small, large, mom and pop for sure. So a few things. One, if you're, the first thing you have to do is before you start selling, which is what mom and pop, which is what everybody wants to do because it brings in income that you can then hire a legal team or an accountant or a regulatory advisor or a lobbyist or something like that. Until you get to that point, you need to lock it down. You need to keep it secret. You cannot keep it public. You can talk to people about it, but they need to sign NDAs, right? Because if you ever wanted to protect from a patent perspective, lock it down. If nothing is public, again, this is pre-sale, but if nothing is public, then your year hasn't started. Everybody's under NDA. And yes, I know there are people that don't want to sign NDAs, but you have to make that gut decision whether you want to not get the NDA and then have the patent clock ticking, or get everybody to sign an NDA lock it down, and then kind of continue, be able to still, kind of, file a patent once you start selling. Okay, now let's